Prosecutorial agreements that induce a defendant's specific performance should be enforced, irrespective of how unpopular a defendant is in the public eye. In essence, we harken back to the age-long principle that a deal is a deal. In the present case, Your Honor, there was a deal. The prosecutor made that clear.
The entry of a nollie pros is the end of that particular indictment, where they've said we're no longer prosecuting you.
So it was a not prosecute you today agreement.
Correct. Exactly what a nollie pros is, by the way.
That's some of the back and forth during the Illinois Supreme Court hearing of the Jussie Smollett case. And yesterday they released their ruling, essentially saying that, hey, there was already a prosecutorial agreement not to move forward with this, that essentially means this case was done then, not when a special prosecutor came in to then charge and get a conviction of the actor who was in Chicago in 2019 in January and alleged that he was the victim of a racially charged attack, including having slurs thrown his way and having a noose put around his neck. He was splashed all over the media at the time. People talked about hate crimes, but then it started coming out after Chicago police spent dozens and hundreds of man hours investigating this, scouring all kinds of surveillance cameras and even tracking down the suspects, who ultimately then said they were working with Smollett to create this hoax. Smollett being charged, going through trial, being found guilty in the appeals courts, moving on, and then it gets to the Illinois Supreme Court, where yesterday they ultimately did side with Smollett and told the district court to dismiss the conviction. So what exactly were some of those arguments? It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. The attorney for Smollett in front of the Illinois Supreme Court a couple of months ago laid out the arguments they have, saying that this really shouldn't have come to this point.
Prosecutorial agreements that induce a defendant's specific performance should be enforced, irrespective of how unpopular a defendant is in the public eye. In essence, we harken back to the age-long principle that a deal is a deal. In the present case, Your Honor, there was a deal. The prosecutor made that clear.
That deal ultimately was Cook County State's Attorney Kim Foxx saying, hey, do some community service. You're going to revoke your bond, $10,000, and we're done. Well, there was a lot of other things going on behind the scenes that raised concerns about conflicts of interest and such, but then they brought in the Office of Special Prosecutor Dan Webb, and he then brought charges against Jussie Smollett, and the defense saying that was improper. You're going to hear some of the back and forth from Smollett's attorney and some of the justices of the Illinois Supreme Court. That
Mr. Smollett had agreed to give up his bond, perform community service, and Justice, I think the key...
Now that's one case, but that's not the case that's before the court.
Correct, Justice. I think that's one case, but it's related, because the entire basis of this appeal is saying that the initial case was already disposed of via an agreement. So
obviously the argument is there was an agreement in place, and these second round of charges should not have been brought up. More from the back and forth at the Illinois Supreme Court a couple of months ago when they heard this case.
What is the ultimate relief you're asking for?
Justice, I'm asking for reversal. I think what distinguishes this case from a lot of other cases is we have the investigative body of work by the OSP that is part of the record, where they state what Cook County prosecutors intended to do. So this is not like the Starks case from 1985, where there was some disagreement, as the Second District noted, or the Supreme Court, I apologize, noted that there was a disagreement as to the terms. We have two parties that formed the agreement, that collaborated to draft the initial statement, agreeing that this is the agreement. It was to track a deferred prosecution. The only body or agency that doesn't seem to agree with this is the agency that wasn't in the room when this agreement was drafted, which is the OSP.
The Office of Special Prosecutor, the OSP. And then you had the OSP side of this make their arguments to the Illinois Supreme Court, and more back and forth between that side and some of the justices.
So if there was a non-prosecution agreement, the answer is still no, because it's nowhere in the record as to what the terms of those agreements that would have led to the ability to dismiss those with prejudice. And here's how we can
So
look
your
at this.
position is that even if the state agreed to not prosecute Mr. Smollett, that you would still have the authority to come back after the fact, after that agreement was expressed in open court, and prosecute?
Yes, because the agreement, the entry of a nollie pros is the end of that particular indictment, where they've said we're no longer prosecuting it.
So it was a not prosecute you today agreement?
Correct. Is exactly, yes, correct. Exactly what a nollie pros is, by the way. But
So,
to
counsel,
look at it, yes. One second.
So that leads me to a couple of policy questions. So if we accept your argument today, there are 102 counties, each with an elected state's attorney who has the discretion whether or not to proceed with charges. They can request nollie pros, they can make these kind of agreements. And if the same situation were to arise somewhere else, you're saying that that discretion is going to be upended by the potential for a special prosecutor coming in, or special prosecution being commenced, which would, in circumstances like this, impede state's attorneys from exercising their discretion?
No, so I think the answer is no, if I'm understanding your question correctly. None of the 101 counties have been impeded at all. I mean, this has been almost 6 years since the underlying incident occurred, and to my knowledge, there's not a single prosecutor.
My question is, could that happen?
Theoretically.
If we're setting a precedent by ruling in this case, what would stop that from happening? Having, so a situation like this, state's attorney decides it doesn't want to proceed. It, makes the motion to nollie pros, says we've entered into an agreement, and then the judge accepts it, and then whether it's a member of the public, by way of the public outcry that we saw here, or a victim's family or something, then find a way to say, we're going to try and proceed with a special prosecution. We're going to resurrect these charges.
Yeah, there's nothing special about this case. I would posit the following: nothing has, the hypothetical that you've just raised has been in existence since at least 1985 because of Sparks and Boyd's case. Nothing has changed. This is not setting some sort of new precedent. The concept of a nollie pros and what it means as it relates to finality, what's on the record and what's not on the record, that if this court were to rule in appellant's favor, that's where things would change, where this would be a total sea change as it relates to Illinois law.
Well, what did the justices ultimately do? Let's go ahead and take a look at that conclusion from the 32-page ruling. We are aware that this case has generated significant public interest and that many people were dissatisfied with the resolution of the original case and believe it to be unjust. Nevertheless, what would be more unjust than the resolution of any one criminal case would be a holding from this court that the state was not bound to honor agreements upon which people have determinedly relied. As the Supreme Court of Pennsylvania recently stated when enforcing a prosecutorial promise not to prosecute, it cannot be gainsaid that society holds a stronger interest in the prosecution of crimes. It is also true that no such interest, however important, ever can eclipse society's interest in ensuring that the constitutional rights of the people are vindicated. Society's interest in prosecution does not displace the remedy due to constitutionally aggrieved persons. That court further noted that the consequences of failing to enforce prosecutorial promises when a defendant has relied on them to his detriment. Contrary results, quotes, would be patently untenable. It would violate long-cherished principles of fundamental fairness. It would be antithetical to and coercive of the integrity and functionality of the criminal justice system that we strive to maintain. So therefore, we reverse the judgment of the appellate court, reverse the judgment of the circuit court, and remand the case with directions to the circuit court to enter a judgment of dismissal. So that means the case against Jussie Smollett is over. And what twists and turns that went. If you recall, when he was sentenced to jail, he served, 6 days and was released. But before he went in, he put his fist up in the air and said he is not suicidal. He's not suicidal. And if he was guilty, he would have said something earlier that he was taken behind closed doors. Well, now he's free of these charges. So that's the latest from the Illinois Supreme Court. All right, like, subscribe, hit that notification bell. Wake up with us. It's Illinois in Focus Daily.